For those who are just joining or who may be wondering, Glenn Spencer is with us. He is changing rooms in his house because of outside noise. And when he comes back on, we're going to start right at the top of the hour so that we can get right to the subject. We're not sure. Glenn is very willing to take questions. He does have a slide presentation that he's going to offer, and we are recording the conversation so that those who would like can refer back to it. So when Glenn joins us, we'll be ready to go. And we thank all of you who are joining us. We hope everybody is having success with staying well and staying safe. And remind anybody who needs a reminder that there's lots of information on the COVID crisis on the Chamber's website. And so with that, Glenn Spencer has been able to join us. And I want to thank Glenn for offering to take some time here with us at the West Virginia Chamber this morning. We have several good friends who are joining in for information about the PRO Act. And you'll be getting very good information because Glenn is one of the most knowledgeable players in the country on this topic. Glenn is the Senior Vice President of the Employment Policy Division of the U.S. Chamber of Commerce. He oversees the Chamber's work on immigration, retirement security, traditional labor relations, human trafficking, wage, hour, and worker safety issues, EEOC matters, and state labor and employment law. Before joining the Chamber of Commerce of the United States in 2007, Glenn spent 6 years at the U.S. Department of Labor in the Office of the Secretary, serving as the Deputy Chief of Staff and later as the Chief of Staff to Secretary of Labor Elaine Chao. Earlier in his career, Glenn was engaged in issue advocacy and grassroots lobbying for Citizens for a Sound Economy. He also worked as a senior analyst in the research departments of the National Republican Senatorial Committee and the Republican National Committee. His articles have been published in numerous leading newspapers and publications. He's appeared on nationally syndicated radio and television news programs. He holds an MA in International Affairs from the George Washington University. And I am pleased to be able to welcome Glenn. I would just say very quickly before turning the program over to Glenn, a reminder, we are going to take questions. This program is being recorded so that we can refer back to it for some of the great information that Glenn is going to provide us about the PRO Act. I'm also welcoming to today's call Mark Carter, who chairs the Labor and Human Resource Committee of the West Virginia Chamber of Commerce. Mark is also very involved at the Chamber of Commerce of the United States. I would imagine Glenn maybe is going to make reference to that. And Mark has provided a paper on the PRO Act, which we are going to make available to those who request it. So let us know if you would like to have a copy of Mark's paper outlining some of the hot topics connected to the PRO Act. Glenn, with that, I want to turn the program over to you, if that's okay, and let you just take it and run. So thank you, everybody, for joining us, and welcome, Glenn Spencer.
Great. Thank you, Steve. And it's good to be with a West Virginia audience again. As Steve mentioned, we're going to be talking about the PRO Act. We can go on to the next slide. This is the Protecting the Right to Organize Act, which, as you can gather from the photos here, relates to unions and union organizing and those sorts of topics. We can go on to the next slide. So this legislation has been introduced in Congress. It has already passed the House of Representatives with a 225, actually go back, yeah, there you go. It passed the House with a 225 to 206 vote. Only one Democrat voted against the bill in the House. The legislation is now over at the Senate. It has 47 co-sponsors. Senator Schumer, who's the Senate Majority Leader, he has said that if he can get to 50 co-sponsors, he will bring the bill to the floor for a vote. So there are 3 Democratic senators who have not yet co-sponsored the bill, 2 from Arizona, and 1 from the state of Virginia. Those 3 have indicated some concerns with the bill. They're getting a lot of pressure from the unions to get onto that legislation. As of yet, they have not done so. So that's part of our mission, is to make sure that those members do not get onto this bill. We go on to the next slide. So why are we talking about this legislation at all? It's because union membership has declined pretty dramatically since the 1950s. Back then, roughly 1 of every 3 workers was a union member. Now that is down to just a little under 11%. But in the private sector, it's just 6.3%. So this is a pretty dramatic decline in membership. It's obviously got unions very, very concerned. They've tried a number of things over the years to reverse that decline in membership. And this is just the latest effort in that. So this is a significant and frankly quite dramatic change to labor law, all intended to reverse this membership decline. We can go on to the next slide. We'll talk about some of the key provisions in this bill. So the first one, we can go on to the next slide there, is the issue of private ballots. So the way that the law currently works is if unions wish to organize a workplace, what they will do is they will talk to workers, they will get them interested in an election. And when they feel as though they've got enough workers signed up for that election, they will then ask the federal government, the National Labor Relations Board, or NLRB, they will ask them to actually go ahead and hold that election. It's typically done via private ballot. So workers will go into a voting booth, cast their vote just like they would in any other election. And if the union wins, they are certified, and the employer must begin collective bargaining with that union. If the union loses, that's typically the end of the process. However, under this bill, under the PRO Act, if the union were to lose the election, they can then raise charges of interference. They can claim that the employer in some way interfered with the election. And if the NLRB agrees with the union, then the union can get certified via card check instead of a private ballot election. And what that means is, rather than have workers go into the voting booth and cast their vote in private, unions simply can walk around and get individuals to sign a card like the one you see on the screen here. And if enough workers sign the card, then the union is certified. The concern is that because these cards are signed in public, the union knows exactly how every worker voted based on those signatures. Workers can be exposed to harassment and intimidation to sign the card. So they may sign the card for reasons that have nothing to do with actually wanting the union in place, but that is what would be considered their vote under this process. So we say that the PRO Act essentially undermines private ballots in union elections, and it really does. It sets up that process where it's more likely you're going to get card check certification than you would a private ballot election. We can go on to the next slide. We also have concerns about the bill, how it deals with worker privacy. So under this legislation, employers would have to turn over to unions a great deal of information about their workers, things like their home addresses, home phone numbers, personal cell phone numbers, personal email addresses, shift locations, work schedules. They would have roughly 2 days to put all this information together about each of their workers and share it with the union in an electronically searchable format. Now, whenever we talk about this privacy issue, we always hear from individuals, well, can I opt out of this? Couldn't I say I don't want my information turned over? And the answer is no. Workers have no opportunity to opt out of this disclosure under the PRO Act. It's simply the information has to be turned over, or else the employer is considered to be in violation of the law. Now, when workers start getting these emails and phone calls and home visits, they might be a little bit concerned, but they're not going to be angry at the National Labor Relations Board in Washington, D.C., which they probably never heard of. They're going to be angry at you, the employer, for having turned over this information, not realizing that you have to under the law. So it's a great deal of information that has to be released to the unions. And again, workers have no opportunity to opt out of that disclosure. We go on to the next slide. This bill also would effectively repeal right-to-work laws. As I'm sure you all know, West Virginia recently became a right-to-work state, but this bill would overturn that without any action by the state legislature. Well, what happened under this bill is if there were a workplace that had a union in it, every worker in that bargaining unit would be forced to pay union dues. And if you didn't want to pay those dues, you could be fired. I mean, that's the bottom line. Workers would have to pay dues under this bill, and that would apply in every right to work state. So West Virginia, Nevada, Texas, Florida, all of these states that have right to work laws, and 27 states do, those laws would all be overturned. And this would be back as it was back when the National Labor Relations Act was first passed, that essentially you had a closed shop. If you wanted to work in a facility, you had to be union, you had to pay your dues. And that's what would happen under this bill. We go on to the next slide. The bill also deals with independent contractor definitions. Under current law, there are really two types of workers. One is a regular employee. You get a W-2, you get Social Security contributions withdrawn from your paycheck, all these sorts of things. You're subject to overtime and minimum wage laws. And then you have independent contractors, who are individuals who work for themselves. They set their own hours, they provide their own tools, all those sorts of things. And that's how they work. Under this bill, there would be a new definition for who is an independent contractor. The bill would import a statute from California known as AB 5. And AB 5 includes a 3-part test for determining independent contractor status, factors A, B, and C. I'm not going to read them all. You can see it on the screen. Bottom line is that this is an extremely stringent test. It makes it very difficult for someone to be considered an independent contractor. So essentially, under this bill, almost everyone would be considered an employee for purposes of labor law, which means that independent contractors for the first time would be subject to unionization. They could all be forced to join a union if there were a vote amongst a group of independent contractors, which would mean that they would lose all the flexibility and earnings opportunities that they have now. We go on to the next slide. The PRO Act also legalizes what are referred to as secondary boycotts. And if you are not familiar with this term, that's hardly surprising, because secondary boycotts have been illegal since 1947. Congress specifically outlawed this kind of activity because it was so disruptive to the free flow of commerce. So what it means is, as you can see by the first bullet, if the union wishes to organize company A, that means that's where that dispute is. Unions can't go to company B, some innocent third party, and try and force that company to stop doing business with company A as part of their pressure campaign. That is secondary activity. That is unlawful. Under the PRO Act, that would actually be legal. So strikes, pickets, boycotts could all take place at businesses that actually have no part of any labor dispute. And so if you think about who this could involve, it's any of your, let's say you're the target company, any of your suppliers, vendors, banks, financial service providers, contractors, insurers, franchisees, tenants, any business that you have a relationship with could now be targeted by that same type of union activity if secondary boycotts were legal. So the example I like to use is, let's say there's a hospital and the union wishes to organize the hospital. Hospital is company A, that's who the union has a dispute with. Well, maybe the union doesn't want to picket the hospital. So what they decide to do is to say, okay, this hospital won't be able to function if they can't get insurance. So we're going to find a company that insures this hospital, and that's who we're going to picket, and that's who we're going to protest. We're going to try and force that insurance company to stop doing business with the hospital unless the hospital gives in to what we want. And that's what happened. The insurer, who is simply doing what they always do, providing insurance, is suddenly dragged into this labor dispute. They've got picketers and protesters outside their offices every day, makes it very difficult for them to function. And so eventually what they have to say to the hospital is, hey, either we're not doing business with you anymore, or you need to give into this union and get them off our back. That's the whole objective of this, is to ratchet up the pressure on the targeted company by impacting their business relationships with all types of different companies. And again, this activity has been unlawful since 1947 because it was so disruptive to the free flow of commerce. We can go on to the next slide. The bill also includes a very vague and open-ended definition of what is called joint employment. Under joint employment, it's a concept that exists in current law, but it simply means that two different employers exercise enough control over an individual employee that they are both considered to be the employer of that individual. That's what they're called, joint employers. Now, the current test for joint employment is that you need to have direct and immediate control over a worker, and that you're actually exercising that control. That means that I would have enough control over what you as a worker do on a daily basis, and I actually exercise that control. And if two of us are doing that, we're both joint employers. What the PRO Act would do is replace that standard with a test using indirect indicators of control, or even just the potential to control a different worker. What that essentially means is, let's say you have a company, you hire a janitorial services firm to come and provide cleaning services for you. You probably are going to set out some conditions around that service. Maybe you don't want anyone coming in before 6 p.m. And there's probably a time that you want them to wrap up operations as well. Well, under this new test, you're actually exercising indirect control over the hours of work that those janitorial contractors are providing. So you actually could be considered a joint employer of those contractors. That would mean that the company that you thought you just had a contract with, suddenly you are actually the employer of those individuals who are coming into your office. Another thing you might do when you have an agreement like that is you're going to have a contract in place. And in that contract, you're probably going to reserve for yourself the ability to control who is actually allowed onto your work site. For example, you may not want someone on your work site who's carrying a weapon or is intoxicated. And you're probably going to reserve for yourself the right to get those individuals out of your building as quickly as possible. Well, by reserving that control for yourself, you are actually reserving the ability to impact terms and conditions of employment, meaning you could be considered a joint employer of those individuals under this bill. So thinking about how broad and vague that standard is, if this bill were to pass, joint employment relationships could be found in a whole range of different scenarios, such as franchising, which of course is not just fast food, right? Franchises are all over the place in many different types of industries. Things you subcontract out for, like IT services, security, janitorial services, contract labor. All of those relationships could land you in a joint employment relationship, meaning essentially you have joint liability now for violations of the National Labor Relations Act. So what we say about this is that the PRO Act would hold businesses liable for workplaces they don't control and for workers that you don't actually even employ. But you could face liability for those individuals under this, this new joint employment test. Go on to the next slide. This bill would also encourage class action lawsuits, because one of the things it does is it prohibits employment arbitration agreements. So many companies, when there's a new hire, that new employee will sign a document that says, if I've got any workplace disputes or issues, I will take that to arbitration rather than hiring a lawyer and filing class action litigation. This bill would make those arbitration agreements essentially unlawful. Now, not only do we think this is bad for employers because it exposes them to more class action litigation, but frankly, we think it's not good for workers either, because arbitration is actually a fairer, faster, and better process. The Chamber did a study a couple years ago, and what we found was that in arbitration, employees tend to win more often. They also win higher amounts when they go into arbitration than if they go to class action, and they get a faster resolution of their disputes. Now, you might ask, well, if it's so great for employees, then why would employers want to use arbitration agreements? And again, it's simply because it avoids needless class action litigation, keeps them out of court. But under this bill, any workplace dispute could go straight to class action litigation and skip the whole arbitration process. We can go on to the next slide. Now, the bill includes some new penalties. Not surprisingly, it includes those penalties only on employers. There are no new penalties for any illegal union activity under this bill. The penalties are substantial, up to $100,000 per violation. And what's important to note about these penalties is that they can be assessed personally against company directors and officers. So it's no longer the fine being assessed against the company. It could be assessed against you personally. In addition to those penalties, there are penalties for failure to comply with a board order of up to $10,000. And critically, workers can now skip or could now skip the NLRB's adjudication process and go straight to court. Under current law, what happens is that if there's an unfair labor practice charge or some issue related to union activity, workers go through the NLRB's adjudication process. There are specific procedures in place to hear those complaints, to adjudicate those complaints, to settle them. Under this bill, don't need to do that. You can just go straight to court. And of course, when you go to court, what does that mean? There are liquidated damages, punitive damages, attorney's fees. All those things could be charged against the employer under this bill. Let me go ahead on to the next slide. So where does this stand now? Well, we're encouraging everyone to get involved as best you can. The number is up here on the screen for the General Congressional Switchboard that you can use to have them patch you through to your relevant member of Congress's office. The email addresses, well, the website addresses are up there for both the Senate and the House. On there, there are always ways to send emails and letters to your members of Congress. And then if you go to our website at stoptheproact.com, there's a letter writing tool, lots of information about this bill. And we'd encourage everyone to get involved. Now, I think here we should probably talk a little bit about Senator Joe Manchin, who, as you all know, is one of the key senators right now, given the split nature of the Senate, which has a 50-50 split. Senator Manchin recently came out and co-sponsored the PRO Act, which was a little bit of a surprise to people because he had remained off that bill for many years. Now, we had a conversation with his staff, and I'm sure Steve and others may have too. What he mentioned to us was that, or his staff, I should say, mentioned to us was that he looked at this as a little bit of a free co-sponsorship because he didn't think the bill was actually going to come to the floor. Under the filibuster rules, you would need 10 Republicans to vote for the bill if it were to make it pass. He didn't think that was ever going to happen. And he also views himself as in control of whether the filibuster rules ever get changed because he and Senator Kristen Sinema from Arizona have resisted changes to the filibuster. So because of all that, he essentially viewed this as a free co-sponsorship, but still did have some concerns about the bill. So even though he is now officially on board as a co-sponsor, I would encourage folks to continue to reach out to his office to continue to discuss this issue with him because he may decide that he doesn't want to vote for it if it ever got to the floor because of those concerns he has. In addition, perhaps he would insist on some changes to the bill. Not that we think there's really a viable compromise on this, but if there are changes made in the Senate, the bill then needs to go back to the House again, which would certainly prolong the process. So I'd encourage people to continue to reach out to his office and just share your concerns about the bill and let him know how you feel. So with that, happy to take any questions, or Steve, if you've got any comments you'd like to make here as well.
Glenn, thank you for a terrific overview. I have seen a couple of questions come in. Maybe we should get to those first. Brian, do you have those questions? Are you able to pull them up?
I am, and I was just going to remind attendees, we have a couple different ways to ask questions. You can type them into the chat box or the Q&A box, or you can raise your hand and I can allow you to talk. And so I see Charlotte Norris has her hand raised. So I'm going to go ahead and, Charlotte, allow you to talk here, and in that way you can just go ahead and ask your question. And be sure to unmute yourself, Charlotte.
Thank you. I had submitted my question in the chat. I'm curious about the liability for officers and directors. Is there any exception in the PRO Act right now for officers and directors in nonprofits and not-for-profits?
I don't believe so. I'd have to check the specific language around that, but I don't believe there are any exemptions for nonprofits from those penalties.
Okay, thank you, Charlotte. We have a question from Steve Roby, who is the chairman of the West Virginia Chamber of Commerce. And his question is, are the changes in the definition of employee versus independent contractor controlling for IRS or employment tax purposes?
The answer to that is no. They apply only to labor law. So the change here would mean that under the National Labor Relations Act, many, if not most, independent contractors would be considered employees. Now, what that means, of course, is they are now subject to unionization, and that would be the first time since passage of the act that independent contractors have been considered eligible for unionization. Now, we've heard a lot of pushback from the unions around this because people have assumed that, well, if you're changing the definitions, it's not just for labor law, but it's also for the IRS purposes, as you mentioned, but then also for purposes of overtime and minimum wage and those sorts of things. And it's not quite that broad. But if you think about how this would function, independent contractors by definition tend to be scattered, right? They're not all working at one facility in most cases. So any ballot that gets done with those independent contractors is probably going to have to be a mail-in ballot, which would mean, and we've seen this in other instances where a lot of people aren't going to participate in the election. Maybe they didn't get the notice, or they looked at it, didn't know what it was, and they just threw it away, or whatever it is, that they may not participate in the election. Now, under this bill and under current law, union elections are decided by a majority of those who show up to vote. So let's say you have a bargaining unit of 100 independent contractors scattered around West Virginia. If only 10 of those people actually vote, you only need 6 workers for the majority. And then all 100 of the independent contractors in that bargaining unit would now be covered by the union contract, meaning their hours of service are going to be determined by the contract. Their wages are going to be determined by the contract. All those things that make them independent contractors now, the freedom to choose when and where and how you work, are going to be covered by the union contract. So yes, the bill only applies to labor law, but it's actually a lot broader than unions would suggest in its ramifications. And I would also note, once you put this ABC test into a federal statute, it will start to migrate into other areas of law. And we've already seen legislation introduced that would put the ABC test into place for purposes of state and federal unemployment insurance. The Department of Labor is already working right now on a new regulation for independent contractors. So yes, under the bill, this applies only to labor law, but I think the ramifications are much broader than just that.
Thank you, Glenn. We have another hand up, and then we have a couple in the Q&A. So I'm going to go ahead and get to Mark Carter, who has his hand up. Mark, make sure you unmute yourself as well when you ask your question.
Thanks, Brian, and Glenn, thank you very much for speaking with us this morning. There are a couple points that I wanted to ask you to hit on, if you would, because I think they'd be of interest to this group. The first one is the PRO Act's call for personal liability of officers and directors if they committed an unfair labor practice or had constructive knowledge of an unfair labor practice and failed to prohibit its commission. And the second one, if you would, is I'd be grateful for your thoughts on the executive order that the president issued on April 26 on worker organizing and empowerment, and his call for recommendations from the chair of that task force and its membership.
Sure, and Mark, good to hear your voice. It's been way too long since we've seen each other. With regard to the penalties, so yeah, as mentioned in the presentation, those penalties can be applied to individuals, and as Mark mentioned, it's an individual who either committed the unfair labor practice or had knowledge of it and didn't stop it, or put in place policies that promoted the commission of an unfair labor practice. Now, when you think of an unfair labor practice charge, it's probably a term that's not familiar to everybody, but essentially it means that there's a violation of the National Labor Relations Act. Now that can be a significant violation. It can mean that you fired somebody unlawfully in an attempt to stifle a union campaign, or it could be something really minor like a handbook violation. For example, most employers will have an employee handbook that you give to workers when they start at your facility. And those handbooks spell out all kinds of different policies in the workplace. During the Obama administration, there was a concerted effort by the National Labor Relations Board to examine those employee handbooks and to find little nitpicking kind of things in there that the board didn't like, and then hit employers with unfair labor practice charges. And it could be things as innocent as requiring employees to be courteous in the workplace. It could be things like encouraging them to not discuss publicly sexual harassment charges that might be filed against an employee. Those sorts of things that are fairly standard in most handbooks actually were found to be violations of the National Labor Relations Act. So you could have a situation where an employer who is not sophisticated in labor law, doesn't have a big team of lawyers, inadvertently commits a violation like that, and suddenly could be on the hook for penalties. Now, I'm not saying that a handbook violation is going to get you a $100,000 penalty every time, but if you've got enough of those things, it certainly could. And again, that penalty could be applied against you personally, as opposed to the company as a whole. Second thing Mark asked about was the White House executive order on unions and union organizing. This was signed last month. Essentially sets up a new task force, if you will, within the White House, composed of just about every cabinet secretary there is. And the idea is to come up with policies to promote union organizing and collective bargaining. Now, you could say that this is perhaps similar to the Supreme Court commission that the president put in place, which is not expected to come up with really much of anything. I don't know how serious an effort this will actually be, but one constraint they'll have is many of the things they would like to do are things that have to be done via legislation, like the PRO Act, for example. So they could call on all kinds of different changes, but unless Congress passes them, not going to happen. What I could see more realistically coming out of this task force is recommendations for new conditions on government contractors. So if you're a federal contractor, this commission could potentially recommend, we would suggest that the administration require neutrality for all federal contractors. In other words, meaning if a union comes to organize your workplace, you will simply just stay out of it. You won't try to talk to your workers. You won't try to say anything about the union. You'll just let the campaign happen. I could see that coming in there. I could see a recommendation that the president issue an executive order requiring federal contractors to allow organizing via card check as opposed to private ballot elections. So I think that's, if there's going to be a practical impact, that's probably more where it lies, is things that the administration can do on their own without Congress, which really means federal contractors and to some extent federal employees too, although they already have fairly extensive union rights. So that's kind of where I see this headed. But yeah, we'll have to see.
Thank you, Glenn. Danielle Waltz with Jackson Kelly has asked a question that ties in with the question asked by Steve Roby. And she says, how does the PRO Act affect the recent independent contractor legislation that was passed in West Virginia during the 2021 session?
Yep, good question, Danielle. Thank you for that. So as some of you probably know, there was an independent contractor bill passed in West Virginia this session that used a single definition for a number of different employment statutes in the state to try and make it easier for employers to figure out how they should be classifying workers. This bill wouldn't necessarily impact that, but what it does do, again, is it would nullify that test for purposes of federal labor law. So all those independent contractors, even though for purposes, say, of state workers' comp or state wage hour questions, you could still remain an independent contractor. For purposes of federal labor law, you're an employee and you're eligible to unionize, and your terms and conditions of employment would be set by your union contract, not the state statute, if you happen to be unionized in a bargaining unit of independent contractors. So the two can still coexist, both laws, but if you wind up in a union setting, because you're considered an employee for labor law purposes, the state statute essentially goes out the window and everything is going to be governed by that union contract for the most part.
Thank you. The next question we have is related to the right to work provision. So the question was, if your bargaining agreement does not require a union facility to be a closed shop, would the PRO Act's language that invalidates right to work laws effectively make all open shops right now closed shops in the future?
Yeah, pretty much. The state right to work law could stay on the books, sure, but it would be, for all purposes, invalid, because every union contract going forward would require those union security clauses. Everyone would be required to pay dues, or technically fees, right? Because somebody under federal law could still say, I don't want to be a member of the union, and then you're not paying dues, but you would be required to pay whatever fees the union decides to charge. And in many cases, those are almost the same as union dues anyway. Bottom line is, under this statute, workers would have no opportunity to not pay those union dues or fees. That would be a requirement of federal law. And so any contract that had that in there, you would either pay the dues or fees, or very likely would lose your job.
I don't have any other questions in the queue right now. I had one question. We talked a little bit about this. This is more on the politics of the act. Currently we have the filibuster in place, and if that's not broken, this bill, I don't think, can get moved forward. Is there any concern, though, that this bill could be viewed as, quote unquote, a filibuster breaker? and used to maybe change the rules of the Senate?
On this bill, I don't think so. The bill that we suspect will be used to try and do that would be S1. This would be the voting reform bill that's going to be coming to the Senate at some point soon. This issue, I don't think rises quite to that we're going to break the filibuster because of the PRO Act. Certainly the unions would advocate for that, and they are advocating for that, but I'm not sure the Senate goes along. One question related to that we do hear is, are we worried about reconciliation? So this is the special process that the US Senate can use to get around that 60 vote threshold from the filibuster and just pass something with 51 votes. And we saw that happen earlier this year with the stimulus bill. I don't think the provisions of the PRO Act would fit into a reconciliation bill. There are very strict rules about what can go in there. Former Senator Byrd from West Virginia put in place what was called the Byrd Rule, which means that anything in the reconciliation bill has to really have a direct tie to taxes and revenues and that kind of thing. I don't see any provision in the PRO Act that does that. You might argue that the new penalties, because it would be revenue to the federal government, sure, you could count that, therefore it's a revenue bill. Well, it's really not. I mean, the penalties are a small part of this bill. They're not designed to raise revenue. They are designed to deter behavior. So there's really no direct tie. So I don't think any of the provisions of the PRO Act would survive the Byrd Rule if unions tried to squeeze it into reconciliation, say on an infrastructure bill or another budget bill.
Thank you. And in we just had our question pop in. Is there any part of the PRO Act that you would view as obviously unconstitutional should this somehow make it through Congress and be passed into law?
Really the one section in there that would raise some concerns, and I don't know if they rise all the way to constitutional concerns, but there's a piece of this bill known as the Persuader Rule. And what the Persuader Rule essentially does, it would say if you're an employer, you got a union campaign, you go out and hire a lawyer to help you navigate the rules and figure out what you should say to workers, that kind of thing, that arrangement has to be disclosed. So you would need to file financial disclosure forms with the Department of Labor, indicating who you've hired, what services they're providing, how much you're paying them. And likewise, the lawyer would have to file his or her own form saying, here's who I'm working for, here's how much I'm getting paid, here's what I'm doing, and here's all the other labor law clients I have. Even if those clients have nothing to do with this current labor dispute, you're supposed to disclose all of them under this concept. Now, back in the Obama administration, the Department of Labor attempted to do this exact same provision through a rulemaking that was struck down by a court. Does that mean it's unconstitutional? Well, the judge didn't get quite that far, but the rule was struck down. So I think there would be litigation around at least that piece of this bill were it ever to pass. The rest of it really is up to the discretion of Congress. So things like changing the rules around private ballot elections, things like the penalties, all that sort of stuff is up to the discretion of Congress.
And Glenn, if I may, I'd like to remind the people who are on this call that the Chamber's Committee on Labor and Human Resources will be meeting tomorrow, chaired by Mark Carter, and has this and several other federal issues on its agenda for discussion. And we anticipate further conversation about this topic at the upcoming Business Summit and annual meeting, which is September 1st, 2nd, and 3rd of this year. So we certainly are going to keep this conversation alive. As we can tell from the questions we're getting, there are lots of good questions. And this is a topic of major and great concern to many employers, certainly in West Virginia, as is the case in so many other states. I don't want to cut us off here. I want to take a minute to see if there are other questions or comments while those of you participating are thinking of whether there are questions or comments. I will take just a moment to thank Glenn for an, as usual, outstanding presentation. I would remind listeners that the conversation is recorded and will be made available so that you can go back and pick up various pieces of it. And Glenn, thank you as always for an in-depth and very helpful look at what is potentially a great problem in overturning so many long-held aspects of the National Labor Relations Act. If there are no further questions, Brian or Glenn, do you want to sum up, or shall we just say thank you and goodbye to everyone?
Well, I just say I appreciate the opportunity to speak to the West Virginia Chamber, and again, it's great to be with a crowd from West Virginia again. And just last thing I'd say is, take advantage of the opportunity you have as citizens of West Virginia to reach out and talk to Senator Manchin about this bill. Even though he's co-sponsored, it's still really important that he hears from his constituents what they think about the proposal.
And while you were speaking, Glenn, I didn't get a question, but I've had several comments that have come in saying that the information has been useful and helpful and much appreciated. So once again, thank you so much for such a helpful overview of the PRO Act.
Great, thank you.
Thanks all, stay safe and stay well, and we'll be back in touch. Thank you.